Hello, and welcome to Advisory Explained. I'm your host, Kosie Kritzinger. Join me in this series, this podcast where we discuss the complex world of advisory. We dive deep into very specific topics in the world of mergers and acquisitions, due diligence, tax, fiduciary services, and so much more, where we take complex topics and we break them down into smaller, bite-sized, palatable portions for you to understand and to understand where we can assist you. Welcome back to another episode of Advisory Explained, where we take complex topics and we break them down into easy, digestible points. Today, I've got a big privilege to have Pieter Janse van Rensburg with me in the studio. Pieter, welcome.
Thanks very much, Kosie. Pleasure to be here.
Fantastic. So today's discussion is it's a difficult discussion, just because it's not really a known point. So we're going to discuss a little bit about rectification and what it is, where it fits in, etc. But before we get there, Pieter, would you mind just introducing yourself, who you are, what you do, where you fit in, etc.?
Yes, Kosie, thank you very much. I'm a partner at AJM in our corporate tax division. So I'm one of the founding partners along with my colleagues who you've met previously. We just absolutely love doing tax and everything related to tax, implementation, case law, litigation, everything around that. So that's what we do and what we have an absolute passion for.
Fantastic. Thank you for that. Pieter, so question, what is rectification?
Kosie, rectification is not necessarily a tax concept. When we talk tax and when we delve into tax matters, we usually look at the legislative provisions underlying. So we look at the Income Tax Act, at the Value Added Tax Act, securities transfers and all the rest. We tend to run to legislation to look at certain matters and how we can address it. Rectification, however, is not a specific tax concept. Rather, it's a concept that we find in the law of contract. So it's a common law concept, and it's really a mechanism that are available to contracting parties where they've made errors in implementation around certain agreements that they've entered into. So rectification is often referred to as an equitable remedy. And it's really to assist parties where they've thought that they are agreeing on something and what they've actually implemented is something else. So rectification therefore requires that there's a common error between the parties. The foundation of the law of contract, and it's not only like that in South Africa, it's that on a global basis, is a contract comes into in existence where you and I agree on certain things. We agree on the subject of the sale, we agree on the price, we agree on the terms, certain what they refer to as essentialia of an agreement. Now, if there's a common error between the both of us in terms of what we have agreed, we've agreed on that basis, so that must be the contract. We've agreed on what the subject matter is, a sale of shares, or a price, or the exchange mechanism. But somewhere along the lines, as part of the implementation, something happened. Then the remedy of rectification is there to assist us in amending not our agreement, because the foundation of the contract is what we agreed upon, but the instrument that we used to implement it. Typically a contract or a resolution that serves as the underlying instrument to our agreement, and something went wrong with the instrument. So that's what rectification assists us to do, is to go and correct what we've inadvertently done wrong.
Okay, fantastic. I think there's a lot of questions in terms of rectification, and things that I sort of want to just throw out there is when do you go into rectification, and what are mechanisms, what are tools of rectification? Does an addendum to a contract meet the requirements of rectification, or is that a basic version of it? And then also, is rectification possibly only something that can happen by way of a court?
Yeah. Kosie, so perhaps to give you some context and to answer your questions around that, maybe I should use an example. There was a very good case coming out of the UK courts a few years ago about the famous cricketer Michael Vaughan. So Michael Vaughan, when he retired, he went to the BBC and he participated in their commentary box as part of the commentary team. And somewhere along the line, in terms of contract renegotiations and the renewal of his contract, the party still thought he is contracting as Michael Vaughan, the individual, the natural person, because that was the first basis on which the agreement was done. Later on, when the contract was renewed, they were under the impression that it was Michael Vaughan Productions, a private company that he owns and that does all of the promotional work that he participates in. So that's a classic example of agreement between the parties, but the contracting party, there was an error on. Is it Michael Vaughan or is it Michael Vaughan Productions? So what is the mechanism there? So common error, yes, there was error in the contracting parties, who that might have been. So what you then is required to do, you can't simply add an addendum to the agreement, because rectification requires the correction of the instrument itself. Okay. So an addendum to an agreement is not amending the instrument, it's merely amending the intention. So that's why it's important that it's the instrument itself. So what are the requirements? Do you need to go to court? What do you do? How do you go about rectification, or is it only inter partes that you can correct? The problem or the difficulty with rectification in tax law is that, other than in a normal civil type of agreement, it's only the contracting parties that are affected by the consequences of the agreement. But the way that tax legislation works is that revenue authorities, and it's not only SARS locally, it's HMRC or it's the Canadian authorities, whoever it might be, they get automatic rights as a result of the consequences of agreements. So what typically happens, and we see it especially in foreign jurisdictions, is that when parties apply to a court to have the instrument rectified, that either the revenue authorities are merely notified or they are added as a party to the litigation. So when the court does then in fact offer rectification, the revenue authorities can't capitalize on that common error that was made. So typically what we see in foreign jurisdictions, and we unfortunately have very limited scope and precedent in South Africa, is that where there is a material error and parties approach a court for that common error to be rectified, that the revenue authorities are added as a party to the litigation. So that's where the difficulty is, and especially rectification in terms of tax law, which in its infancy in South Africa, we to a degree recognize the concept, but there's very little precedent on that. It's difficult for the parties to determine what is the process that we need to follow. Can we simply do it inter partes, or must we approach a court? Do you add SARS? What is the mechanism that you use around that? So there's very little set precedent around process, how we should treat tax rectification in South Africa.
That's absolutely fantastic, and I think we are getting to the crux of it, of rectification. How I understand it is, me and you, we decide we're going to do a transaction, and there's a tax consequence, because we're looking at the tax version of rectification today, but there's a tax consequence. But we intended to be a loan, for instance. We did not intend it to be a sale. That's the transaction that we went into. But the wording of the instrument reads or was implemented as a sale transaction rather than a loan instrument, as an example. And now the third party, which is SARS, comes in and says, listen, I take heed of the actual wording of the instrument, and I'm going to tax you according to that. But both of us agree that, well, that was never the intention.
Absolutely. So that's exactly why why rectification is referred to as an equitable remedy. It should serve to assist the parties to correct the honest mistake. Shouldn't allow revenue authorities to capitalize on that honest mistake. To give you a classic example out of the Canadian law, parties entered into a transaction similar to our asset for share agreements, where you transfer asset to a company and and there's an exchange mechanism in terms of shares that are issued. Now, somewhere along the lines between the advisors and the implementing parties, the exchange mechanism that was supposed to be 1 million shares ended up only being 10,000 shares. So obviously there was a huge value discrepancy between the 1 million shares and the 10,000 shares. But the court, in going through the documents, going through the tax advice that was provided with the parties, said there was never the intention to deceive. The parties really thought that there was value for value exchange in terms of this. a 0 or 2 just fell off somewhere during the implementation process. And it's exactly that. Then the court allowed the instrument, the agreement, the contract that gave rise to the tax consequences to be amended and did not allow the Canadian revenue authorities to capitalize on that mistake.
Absolutely. And I think let's stay within, although we're still in tax, but let's stay within the concept of common law. Thinking of an interesting topic, something you've got questions about, leave it in the comments and maybe we'll do an episode just for you. And the thing that keeps on hitting me is the doctrine of simulation. And how I understand the doctrine of simulation is the instrument and the intention, do they match at the end of the day? And a lot of times in tax structuring, tax consulting, the question and this thing is thrown, this ball into the pot that says, listen, are you simulating something to get to a specific outcome? But if my understanding is correct, then rectification is honest simulation.
Absolutely spot on. That's a very, very good way to define what the doctrine of simulation, what the doctrine of rectification is. Simulation has as its underpin, you and I really think that we agree on it, on what the substance is. We can then go and draw up documents and have papers in place to show the world that this is what we really intended. But courts really don't look at all these documents and resolutions and things because those can be manipulated. It doesn't necessarily speak to what the true intention of the parties are. The true intention is what the subjective intent of those parties are when they entered into that arrangement. Now, often the difficulty is that the subjective intent can only be demonstrated by objective facts and papers that are available. But that's exactly what rectification is, to say, you and I agree on something, but the papers show something else. So why should we capitalize on an error in the papers when you and I really did agree on something else? So in fact, it is honest simulation, if you want to put it as commonly as that.
Okay, fantastic. And let's sort of stay within that world. So currently we've looked at transactional, right? But also in my mind, there is honest other mistakes that could happen. So not necessarily between a tripartite, me, you, and SARS that we have to do rectification. Is there a mechanism for just me and SARS for rectification? For instance, I made R1 million and on my tax return, I typed in an extra 0. Now it says I'm making 10 million rand.
Yeah. We, to a degree in our Tax Administration Act, are starting to venture into a rectification process. We have in our Tax Administration Act, Section 93, that allows where there are processing errors or really honest mistakes. SARS refers to it in the documents, and the legislation itself also refers to readily undisputed errors in either a return or a submission that you've made. And that mechanism is really used to cater for such honest mistakes. Now, taxpayers sometimes abuse those mechanisms where they've really taken tax positions in terms of filings and then claiming that there was an honest mistake. But the simulation is something different. So we can't read simulation into the Section 93 process simply because simulation requires that there be an instrument and the arrangement between the parties. So SARS, just by operation of law, obtains certain rights and taxing rights to whatever the consequences are. So it's a legislative version of rectification, if you will, but it's not exactly the same as the real common law remedy. Other jurisdictions are far more advanced and developed in terms of what they consider for tax rectification. Australia, for example, have doctrines around this, and especially the Canadian courts have advanced to such a stage where parties were under the impression that this is the tax consequences of what we'd agreed on, and subsequently there are legislative amendments with retrospective effect that tax rectification is allowed. But when we agreed, we thought X, Y, and Z were going to be the tax consequences. Now the legislation has changed, so it doesn't really still express our intention and our common agreement at that stage. So rectification is allowed for that. But those systems have been far developed, and it's been in place for many, many years, and doctrines around that has been developed. So that's why it's unfortunate in the South African context that we're really starting to scratch the surface in terms of what is available and how you bring the common law and the legislation in line with each other. As I said, Section 93 is headed in that direction, but we're not quite there yet.
Fantastic. And I think sort of we're touching on a very key point here is not necessarily the doctrine, because we don't have a doctrine in South Africa, but rectification isn't okay, I thought my tax is going to be less, I'm claiming rectification. It's not a get out of jail free card, if I understand you correct.
Absolutely not, because rectification speaks to a common error that there was between the parties in terms of the instrument. The consequences are something completely different. So when you file a tax return, you implement a transaction, you take a tax position in respect of that. You can't use the remedy to go and rectify the tax position that you've taken. That's not the intention at all in terms of which you do that. It really just speaks to the instrument that there was. Now it becomes difficult also in a South African context when you look at it from a practical perspective. What happens once returns have been filed, assessments have been issued, and those assessments subsequently prescribed? What happens if persons only find out about the error 2 or 3 or 4 years down the line? So from a tax perspective, you've had assessments that have prescribed, but the commercial reality must still be rectified. Take the Michael Vaughan example that we referred to earlier. If those tax returns have been filed and prescribed and the parties only later identify there was an error, we actually need to account for the income tax in Michael Vaughan Productions and not in the individual's capacity, where does that leave one? So there's a lot of uncertainty around the tax administrative process and how you align that or marry that with the common law. It's a very difficult position that we find ourselves in.
Absolutely. Let's look at SARS's position and how must SARS treat it. So if my understanding is correct and we've got an intention of a transaction but the instrument is different, SARS taxes the instrument. It doesn't tax the intention. In this case, it taxes the actual wording of the instrument. But now we go to the court, we get a ruling that says, listen, rectify this to a new instrument because that matches the true intention. What is SARS's position? What must happen to them? I know you touched they usually become a tri-party to that ruling, but if you can maybe expand on that a little bit.
So what would typically happen if a court allows the parties to for rectification to take place? The commercial consequences of that must follow, and SARS must tax those consequences. It doesn't make sense if we say, listen, the tax consequences are X, Y, and Z, but the commercial reality is something completely different. If the million shares were issued incorrectly, and it should have only been 10,000 shares, must we commercially now account for the million shares, but SARS taxes it only on the 10,000 shares or the 1,000 shares that was issued? So one would think that the tax consequences must follow the commercial reality, because that would speak to the equality of the transaction and why it is the equitable remedy that it is. But specifically because we have the problem of prescription, SARS is often not allowed. The legislation binds them that they're not allowed to issue revised assessments. And unfortunately, we have seen cases where parties have applied for rectification. Revenue authorities have allowed rectification to take place commercially, but the tax consequences are still based on the original error when it was made. And that's a big problem where I see where our tax administration and the common law will be in conflict with each other, because there is international precedent where, yes, we'll allow you rectification because that's the commercial arrangement, that's a civil law arrangement between each other. But listen, guys, we're not going to allow it from a tax perspective because either your assessments have prescribed or you couldn't meet the burden of proof, etc., etc. So that's the difficulty that I foresee specifically from a South African perspective, especially on income tax, where we have such a short prescription period of 3 years. Often these things only come out at a later stage. So the unfortunate part of this is, while there is this equitable remedy, how does one bring this into the legislative sphere? We don't have a lot of case law around rectification in South Africa, specifically with a tax angle. So my sense is that this is somewhere where the legislator would need to step in. Say, listen, we recognize this concept, but how do we bring it into, or how do we align it with a system that is determined in terms of legislation for our tax administration. Because it's going to be very difficult if the common law and legislation regulating the provisions and tax administration are in conflict with each other. Which one should receive precedence at that stage? And that's going to be very, very difficult. Unfortunately, we haven't seen anything in our courts around that. And it'll be interesting to see what position the courts do take. My sense is that it's very easy to change the legislation around that, because Section 93, and read with the prescription periods in our income tax legislation, makes exceptions to the general 3-year rule and the 5-year rule. And to me, it's a very simple mechanism also to bring in. So listen, prescription doesn't apply, or SARS is allowed to issue revised assessments where a court has granted rectification in terms of certain instruments, or a little bit of a wider wording. So it's not necessarily material amendment to our legislation that's required. It's just a recognition of the concept, and how do we bring it into the legislation?
Do you think there's just too little either knowledge about the possibility to use rectification, or is there some other reason why there's so little case law in South Africa to be able to justify or to get the Revenue Service to make amendments?
Because I think it's often a case of pure ignorance. Often the parties to the contract simply don't know that there is an error in the agreements, or that the revenue authorities don't necessarily interrogate transactions to that degree where they actually go to the source document, say 1 million shares was issued and it should have been 10,000, whatever the case may be. So I think it's often both from SARS's perspective and from contracting parties' perspective that they just simply brush over implementation documents. Yes, everybody's always very concerned about the tax. Is there dividend stripping? Is this deductible? Is that taxable? But where it often goes haywire is in the implementation of the agreements. And I'm not necessarily sure if SARS always interrogates the transaction documents to that extent. So I think it's often a case of just ignorance around that. But we are seeing it a little bit more in terms of transaction implementation, where SARS does request the documents. They do ask a few questions around that. We've seen that in practice, especially over the last 18 months. So I think it's something that's going to become a lot more relevant as we progress. The Section 93 process has been in place since the introduction of the Tax Administration Act about 12, 13 years ago, 14 years ago. But we haven't seen a lot around the common law position. But I think we're going to start to see some more movement in that regard.
Just on that note, I just quickly want to make a comment to all the listeners. Implementation is key. That's where, in Afrikaans, we've got a few sayings, die tekkie die teer tref. That is really one of the most crucial parts of any transaction, of any restructure, of any arrangement that you do, is making sure that your implementation is absolutely done to the T, perfect. And I know that's something that we as Bakertilly Greenwood's Advisory Services, we pride ourselves in that a lot. And I know AJM as well. You guys also specialize, and you also have your implementation team. So make sure, listeners, if you guys have a transaction, it's always good to make sure that the idea, the plan, the tax opinion, the intentions all speak to one another, and then the physical documentation that flows. Pieter, just back to rectification. If we quickly, you touched on it a little bit earlier, but it seems like internationally there is quite a lot of progressive action in the rectification world. What are some of the key jurisdictions that do have it, and how would you see that possibly flowing into South Africa in the future?
Kosie, I think there are 3 leading jurisdictions when it comes to rectification, and specifically tax law rectification. I mentioned Canada previously, the UK and Australia. Those jurisdictions have grappled with this concept of the common law remedy and how it is brought into legislation for many, many years. So I think there are a lot of learnings from South Africa that we can draw from that in terms of comparative studies between those jurisdictions. Because the remedy itself is common law, it's never legislated. So it's the lessons that we can learn from them is how those are brought in line with each other, whether the common law needs to be legislated or whether there is room for courts to interpret both the common law and the legislative requirements. And in a case of conflict, which one receives precedence. So I really do think that, that we needn't start at square one with this, especially the UK and Canada, Australia as well, but especially UK and Canada. There are classic examples about the error in the contracting parties, the error in the price, the error in the actual subject. Is it Naspers shares that I sold, or is it Process shares that I sold? So there are classic examples around all the errors, the common errors that can be made that have been dealt with in those jurisdictions. So I definitely think we can take learnings from those jurisdictions, specifically on integrating common law and legislation.
Absolutely, I completely agree with that. Did you enjoy this episode? Please like, subscribe, and share with your network. Pieter, thank you so much for today. We really appreciate your attendance and having a fruitful conversation on a topic that's not well known. Like I shared with you beforehand, rectification isn't even something that I'm well versed in. So thank you so much for your time. As a closing thought, would you mind just quickly sharing where someone can get in touch with you and your team in terms of either rectification or any other specialities that you guys focus on?
Oh, of course, it's an absolute pleasure. It was good to chat with you around that. Yes, I'm based at AJM's head office in Cape Town. We have offices in Windhoek and Johannesburg as well, and all our contact details are available on the ajm.inc website. So anything related specifically to this topic or anything else tax related, listeners are more than welcome to contact me directly.
Fantastic. Thank you so much.
Thanks
and that is a wrap. Thank you very much for tuning in today, for listening and viewing us. We are excited for the road ahead, and stay tuned for a bunch of very exciting topics to follow. If you think you are someone that could add value on this podcast, or you have an interesting topic you would like to discuss, please reach out to us via email.